The Court of Appeals is now in session.
Good morning, everyone. Welcome to the Utah Court of Appeals for our virtual session today on January 25th. I'm Judge Ryan Tenney. I will be chairing today's argument. With me are Judges David Mortensen and Judge Diana Hagan. We have three cases for decision today, only one of which will be argued. The case that will be argued is Hillam versus Hillam. If counsel for that case could enter their appearances.
Good morning, Your Honors. Alan Moritzen for the appellant, Tara Hill.
Joshua Lee for appellee, Dustin Horncott.
Thank you, Mr. Moritzen and Mr. Lee. As you both know, you're both veterans here. We have 15 minutes per side for argument. Mr. Moritzen, how much time would you like to reserve for rebuttal? We have that noted.
I'd like to reserve 4 minutes for rebuttal.
I think you've both argued here before, but just to make sure that we're all clear on the ground rules. During oral argument, if the attorney who's not arguing could please turn off your video and mute yourself, that will help us with bandwidth issues. As I indicated, 15 minutes per side. And with that, I think we're good to go. Are there any questions before we begin? Okay, we'll hear from Mr. Moritzen.
Good morning, and may it please the court. Our position in this case is simple. When is here, the evidence shows that one spouse transfers marital assets out of the marital estate while contemplating divorce or with the intent of defeating the other spouse's equitable rights, marital rights. The district court, as part of its exercise of equitable authority under 30-3-5, may treat those assets as part of the marital estate for purposes of equitable distribution. Because yes, Judge Mortensen.
And I understand that you want to get onto that substantive issue, but obviously you've received our notice, ask you to come prepared to discuss a couple of other issues. And the one I wanted to first ask you a couple of questions about is the 54B certification. And I wanted to first verify that I understood the record correctly. There was a motion to add the trust as a party early on in the litigation, never ruled on by the trial court, but the trial court did grant a motion to amend Mr. Hillam's petition, which was granted, and that is the mechanism by which the trust was added. Is that right?
That is my understanding, yes.
Okay. And then, and this is just from my review of the record, and if I got it wrong, I'm super curious to have you tell me how. Then I saw that there were acceptances of service from each of the parties, the trust itself and the others who were named. But I never saw, is there an answer from those parties? Did they file formal answers?
And when you say those parties, you're talking about the trust personnel?
I'm talking about everybody except for the John Hillam and Tara Hillam. I thought I saw acceptances of service for 3 other parties.
I will state that I believe that there was, but I may have to submit a Rule 24H letter that provides additional information about that.
Well, let me ask this. This is the more important question, at least for my brain. Did any of those parties file answers?
Well, that's what I thought I was addressing. Is I believe that they did.
All I saw was acceptances of service, and I didn't see formal answers. Let me get to the cusp of the issue. It appears to me, and it seems like the final paragraph of the trial court's order gets to the nub of the situation. Summary judgment was granted on John Hillam's second cause of action in his petition. What I'm getting at is the trust didn't have a separate cause of action that the trial court was ruling on, right?
In terms of, well, no, it did not have a separate cause of action. What it had was a party who our client, Tara Hill, was claiming possessed marital assets. And that was the issue that the district court resolved, was that the assets held in the trust were not marital and were not subject to equitable distribution.
I totally get that within its ruling, it addresses that issue. But I'm still stuck on it, and I think the court's quite explicit in the last paragraph. It is purporting to grant summary judgment on John Hillam's second cause of action in his petition, which I believe is kind of in the nature of a declaratory judgment. Am I got that wrong?
No, that sounds right.
Okay. So the 54B certification is certifying that the second cause of action brought by Mr. Hillam and against, at the time, I guess, Mrs. Hillam, or maybe she had, I guess that it had already been bifurcated. In any event, that was the claim that summary judgment was being granted on. So can you explain to me how under Copper Hills that would be a proper 54B certification?
Well, Copper Hills instructs us to apply 3 factors in determining whether an order is appealable under Rule 54B. The first is whether there are multiple claims or multiple parties. That, as far as I see it, is easily satisfied here. The second is whether the order on its own would result in an automatic right of appeal if not for additional parties. And I think you have that satisfied here because the trust is being dismissed as a result of a declaratory judgment action. And then the third is whether there is any just reason for delay. And of course, the 54B arguments are advanced by trust counsel, and Ms. Hill, wanted to have this issue resolved as quickly as possible, and so didn't object to those arguments. But as far as I read their papers and the trial court's ruling, the determination was made that there was no reason to delay an appeal given that the trust was not going to be part of the ongoing divorce proceedings.
Well, if I could go back, one of the things you just said is that it would be appealable if there weren't the other parties. You'd have to concede that if the only parties to this action were Mr. Hillam and, sorry, Ms. Hill, that would not have been a properly certified order. You can't just take one claim and the parties have other intertwined claims still pending. You can't do a 54B certification under Copper Hills, or do you think you can?
No, I would agree with that. Part of the issue here is the awkward status of a declaratory judgment action where the plaintiff, essentially the plaintiff is the one coming in and saying your claim against the trust is invalid. And so that's the claim that's being resolved. And if you look at Dahl versus Dahl, I think you see a very similar example. I understand procedurally it doesn't map perfectly, but it's her claims against the trust that the district court grants summary judgment on that are then appealed. And that's how I would characterize what happened here. Yes, Judge Tenney.
Let me ask a follow-up to that. In reference to the third factor that Copper Hills talks about, the Supreme Court put a gloss on that third factor, and it said that one of the things we're supposed to look at in determining whether the 54B ruling was proper was whether there was any, quote, factual overlap between the certified and remaining claims. As I read the district court's ruling from the December trial that was just held, one of the things that your client argued there was a dissipation of marital property claim. And the dissipation of marital property claim turned in large part on the intent of John when he put the stock into the irrevocable trust. which seems to be part and parcel of the claim that you've briefed to us on appeal. The intent. I mean, you've asked us expressly to adopt a test under which the intent of the party putting property into the trust would matter. So if that's so, it seems like there's factual overlap. And if there's factual overlap, it seems like that's another reason that you've got a 54B problem. Walk me through why that's not a problem.
Well, I'm not here to tell you that there's no factual overlap. I am here to tell you that there are strong distinctions between the claim that we've advanced on appeal and that we sought the assets of the trust in connection with, which is fraud on marital rights or invalid transfer.
Are the distinctions legal or are they factual?
Well, they're both. And just to, I think the way you characterize the dissipation claim was focused on intent.
Yeah.
I don't think that that's the way that this case law approaches the question of dissipation. If you look at the 5 factors laid out in Rayner, the intent of the party is not addressed as the overarching point that they're trying to address. You have, traditional practices. You have what happened to the money after it was moved. You have depletion. You have obstruction. You don't have questions about spousal consent. And so all of those, if you look at the elements that we're talking about in terms of while contemplating divorce and with the intent of depriving or defeating a spouse's marital rights versus the 5 factors laid out in Rayner, again, I'm not here to tell you that there's zero factual overlap, but I am here to tell you that they do not map onto each other, and that there are some facts that match and that there are some facts that don't match.
But even if they're not purely coterminous, isn't the whole idea of Copper Hills that if you've got claims that have at least some factual overlap, that it's better to avoid piecemeal appellate litigation, keep everything within a single appeal and so forth? Why doesn't that?
And I would grant the point. I mean, I'm not here. This is a messy procedural situation, and part of it is, the length of time it's taken us to get the 54B appeal resolved and to get before this court, so that there's already been a trial held. And so, my primary concern is preservation of my client's rights in terms of being able to get this claim of invalid transfer of marital assets heard on the merits on appeal. And there's no circumstance under which she's waived those rights or that she does not have those rights. And I don't know what the Court of Appeals' best option is if it's convinced the 54B certification was improper, because the order that was issued that contained the findings of fact and conclusions of law is still subject to appeal. Husband's counsel has not yet prepared a supplemental decree that would start the clock on that appeal. And so, does that fold back into that judgment and become part of that appeal? And if so, have we, wasted this court's time and our resources following the 54B certification that was requested by the trust? So those are my primary concerns. I'm not denying the factual overlap, of course, because there is, but they are distinct. They're distinct claims, both factually and legally.
We've taken all of your time on the 54B issue. Why don't you go ahead and spend just a few minutes on the substance? I think that'd be appropriate. Could you just respond to the main point in the red brief that the nature of the irrevocable trust just prevents a divorce court from getting at the assets that are within the trust? If you could just spend a few minutes on that directly, I think that'd be helpful.
No problem. I think that really belies what or defeats what the Supreme Court was talking about in Dahl. I mean, in footnote 13 of Dahl, the court said that this would present a conflict between the equitable principles laid out in 30-3-5 and the trust code. And we don't presume to identify how that conflict would be resolved, or to resolve how that conflict should be addressed. And our point here is that there are some circumstances under which the assets of an irrevocable trust can be returned to the marital estate. There are no cases directly on point in Utah, and that's why the Dahl Court called it an unsettled question of Utah law. What cases there are across the country support our view of the matter, which is, yes, if the irrevocable trust is validly created and is not funded with marital assets that have been invalidly or improperly transferred without the knowledge or consent of the transferring spouse's spouse, then we're going to treat those as marital assets for purposes of equitable distribution. And I recommend to the court Kim, Thames, Schneider, the restatement 34.1, and 6:94 of the Equitable Distribution Treatise, which I think hits exactly on the problems with blessing this kind of activity. Because if a spouse is, and the record is unequivocal on this point, is if a spouse is clearly thinking about divorce, and while thinking about divorce, moves the majority of the marital estate or the assets of the marital estate into an irrevocable trust, and without getting the consent of his or her spouse, yes.
Let me push back on that. I recognize that we're past time. There seems to be some fuzziness inherent in that formulation just there. If the test that we would announce would be whether the spouse is thinking about divorce. Suppose that the spouse is thinking about divorce, but there is some other independent ground, issues, or what have you. What are we supposed to do with that?
Well, as long as part of the motive is to defeat the other spouse's equitable rights, then I think you have to say that this is an invalid transfer.
But doesn't that open the door for a lot of mischief with respect to irrevocable trusts? I mean, if it's even crossing the spouse's mind that divorce might be an option, but they have some other legitimate ground that maybe even predominates within the formation of the trust, why would we say that small marital problem outweighs the bigger advantages that may exist in a given scenario?
Well, and my point is that this is a holistic analysis, but when you have I mean, again, this isn't crossing the mind. This is asking one's personal attorney about putting together a postnuptial agreement and telling your attorney that me and my spouse have grown apart and that she's threatened divorce. So it's not, I'm just, this has just crossed my mind. But putting that aside for the moment, the other part of this that matters is the full and frank disclosure about the effect of the irrevocable trust on those marital assets. And what we have in this record is a representation to the spouse, and I'll wrap up with this, a representation to the spouse that this is to your benefit, this is to protect our family in the event of a calamity, and that you are a named beneficiary, all without an opportunity to review the documents. Sorry.
I
Yes, Judge
apologize. I know you were trying to wrap up, but
no problem.
But this part of the argument is raising another question in my mind, which is the whether this is potentially moot. Because some of the arguments you're making and some of the factors that you're asking us to remand for trial have now been decided by the district court. The district court's actually entered an order saying that the intent was to avoid tax consequences, that she did know about the trust, that the intent wasn't to dissipate. Wouldn't it be, at this point, would it make more sense for you to be appealing the final judgment rather than us issuing an advisory opinion on what the court would have to consider when the court has now already considered those things?
Well, I take issue with referring to it as an advisory opinion because, as I said, although there is some factual overlap, the focus is not the same. And if I could just give one example of that, the court in its dissipation analysis focuses on obstruction. Did you obstruct your spouse? But for purposes of discerning whether there was an intent to defeat equitable rights, part of that analysis is whether the spouse was given adequate factual and legal information to consent to this disposition of the marital assets. You will not find that analysis in the court's findings of fact and conclusions of law.
Let me push back. I mean, this is a hair off of what you just said, but paragraph 145 from the December ruling says, quote, "What is more, it is undisputed that the trust was formed to avoid tax consequences when the beneficiaries withdrew funds from the trust." And the court goes on in other paragraphs. So it's clearly discussing and making findings about the question of what the parties were intending to do when they put that in. And that comes back, I mean, this was my earlier question to you. The test that you're asking us to adopt in the trust issue, by its own terms, largely turns on the intent of the party putting the stuff into the trust. So why doesn't this ruling then hit that same issue?
Well,
why doesn't that create a mootness problem for you?
So let me just say, you say parties. This is not the creation of the parties, right? This trust is the creation of one individual to a marriage, and that turns to my other point. It doesn't matter whether, I mean, you don't see Rule 145 or paragraph 145 saying the only purpose of the trust was formed to avoid tax consequences. So I'm not disputing that maybe part of their aim was to avoid tax consequences. But if the creating spouse is also seeking to defeat the equitable rights of his or her spouse, and that's what the district court never addressed. I mean, if you look at paragraph 159, 159, given this evidence, the court concludes that petitioner did not obstruct respondents' access to details regarding the trust. Nowhere in this order will you find the court disputing that Tara was never given a copy of the trust, never had an opportunity to review the trust agreement, and was never told that her status as a beneficiary under the trust was dependent on her remaining married to John. And all of those issues, which again the court never discussed, are directly relevant to his intent to defeat her rights. Judge Hagan?
So as I understand your argument, you're saying that under the test that you are urging the court to adopt, additional factual findings would need to be made beyond what the court made in December.
Stated far more eloquently than I did, but yes, that's correct. There are additional facts relating to his intent that the court didn't deem relevant to the dissipation claim that we believe are relevant to the invalid transfer claim.
Okay, thank you.
And with that, I'll reserve whatever time happens to remain for rebuttal.
Given the question, you'll have time on rebuttal. Yeah.
Thank you.
Counsel?
May it please the court, Josh Lee for the appellee. Great to be before you today. I'd like to start by addressing the court's preliminary questions about jurisdiction. On 54B certification, the answer to the court's question is actually much more simple. The 54B analysis applies when there are multiple claims or multiple parties. And I'll give the court a citation to this court's own opinion, West v. Thompson Newspapers, 835 Pacific 2nd, 179. It was vacated on other grounds, but what it said as to jurisdiction is, quote, "The Supreme Court's recent analysis regarding the separateness of claims simply does not apply to the certification of final judgments against separate parties," close quote. So there are two different roads you can take to a 54B certification if you're disposing of parties in their entirety or claims in their entirety. And in this case, we were disposing of parties in their entirety. I agree with the suggestion that these claims would likely not be separate because the factual basis for the question of invading the trust really is tied up quite a bit with the question of dissipation.
If she had not raised a dissipation claim in the bench trial that was held a few months ago, would the answer be different?
Probably, if
Just putting the card on the table, so my question's not clear. It feels to me like the factual overlap really comes between the trust issue that's been briefed to us and her dissipation claim. But if her dissipation claim was not there in the trial, then it does seem like these would be distinct, because you'd have the summary judgment proceeding, which was about the trust and its rights to the property, and then you'd have the divorce, which was just about all the other stuff. So if the dissipation claim wasn't there, would we be in a different place?
agree. We would have possibly separate claims and separate parties, but we don't need to worry about the separateness of claims because we have a judgment completely disposing of separate parties, and the analysis is different.
Can I ask you a different? Oh, sorry, Judge Morrison. I think
Just before you shift gears, the citation was 835 P. Second 179.
Yes, West versus Thompson newspapers, and in my recollection, it was vacated on other grounds.
I see that. That's a 1992 case.
Correct.
So how does that inform what the Supreme Court clarified in Copper Hills in 2018?
I don't believe the Supreme Court said the separate claims analysis applies when you're dealing with separate parties in Copper Hills. I don't believe any case has said that, to my knowledge. That's my answer.
Okay.
As for, sorry, go ahead, Judge Tenney.
Please. If we conclude that the Rule 54B certification was improper, do you agree that she will still have the ability to raise this issue regarding the trust in an appeal from the divorce decree whenever it is finalized?
Well, that's a bit of a fraught question. To an extent, yes.
It is, yes.
She has not preserved the grounds, the arguments on appeal. So,
Well, I mean, correct me if I'm wrong on the record. I just want to make sure I've got the record right. The divorce decree has not been finalized off of the December trial. Is that right?
I believe that's right, yes.
So in theory, once that's finalized, she can then appeal from that. And if we've concluded in the interim that the 54B certification was improper, in theory, would you agree that she could then raise those issues there in that appeal?
Subject to preservation arguments, yes.
Right. Okay.
Yes. And I would just urge this court to, when it's reviewing that issue, to keep its focus on the difference between a separate parties analysis and a separate claims analysis, to analogize it to the rule, to interpretation of contracts and statutes. We interpret them so as not to render one part superfluous. If we interpreted the separate parties analysis to require an analysis of separate claims, the multiple parties option would be rendered superfluous. And as to Judge Mortensen's question about answers, it was before my time. I do not believe answers were filed. I believe my understanding is that Mr. Hillam's counsel said, hey, trust parties, we're joining you. You don't need to file answers, just joining you so that we have a joinder of all the parties necessary to determine that issue.
But just to be clear, the trust was a party to the underlying lawsuit, and they were dismissed as a result of the ruling that's on appeal. Is that correct?
Yeah, the trust and its beneficiaries, the non-spousal beneficiaries, yes.
So in your view, you agree with the appellants that the Rule 54B certification was proper?
Yes.
Okay.
It was my client that asked for the certification, and in our view, the multiple parties analysis was very straightforward. And the trial court made the necessary findings on the just reason for delay. The typical reason things get hung up on 54B is claims are often not as separate as parties believe they are, or the district court simply fails to make the factual determinations to support the no just reason for delay conclusion.
And footnote 14 in Copper Hills does seem to, footnote 14 does seem to support your argument that there is a distinction between multiple claim cases and multiple party cases, so long as the court still explains whether there's, whether that factual overlap makes it so that that delay would be appropriate.
Yeah.
Let me ask you a slightly different question. Let me pivot to the mootness question. Do you think that this case is moot, given the court's factual findings in December?
Well, yes, to an extent. To be fair to Ms. Hill, the sticky part of that is she's entitled to appeal those recent findings. So I think, and really, that's kind of a backstop to all of our other arguments. I think the best way to look at that today is on the preservation issue, because whether or not this court considers arguments that were not preserved is to a degree subject to limited discretion. And I think if the court were hanging in the balance as to whether or not to consider the unpreserved argument, these recent findings could be the deciding factor in that analysis.
Can I ask you a question about preservation? Unless, Judge Hagan, you got more questions on mootness. All right, let's go to the preservation issue. You've argued in your brief that Ms. Hill's arguments are not preserved because she made a distinct argument below. It's different than the one that she's argued on appeal. But as I look at the district court ruling from the summary judgment ruling at issue, it's got what I see to be 3 paragraphs of analysis about the question of whether the stock options are subject to equitable distribution. I'm specifically looking at paragraphs 3 through 5 of that ruling. So let's just assume for purposes of my question that you're right, that she made a different argument below than she made here. Wouldn't the fact that the district court spent an entire page of analysis on the question of whether these stock options were subject to distribution get through any preservation problem? I mean, why wouldn't she be entitled to appeal the ruling that the district court actually entered?
Well, she can appeal that ruling, but the question is on what theory. There are, to analogize it to a contract, there are a number of reasons you could attack a contract. Lack of consideration is a very different thing than fraud, which is a very different thing than unconscionability.
Right, but so to use your analogy, if the party had argued unconscionability, but then the district court issued a ruling on lack of consideration, why couldn't the party appeal the lack of consideration ruling and attack it on its own terms?
Oh, well, the party could appeal the lack of consideration ruling, but not argue that it was unconscionable. Sure.
Okay, right, but here on paragraph 5 from the summary judgment rule, quote, the law as explained by Hancock in the moving papers is that assets in an irrevocable trust are not divisible and should not be considered part of the marital estate. Paragraph 3, the court does not find that the stock options are subject to equitable distribution. I mean, once the court says in paragraph 3 that it does not find that the stock options are subject to equitable distribution, why can't she come in and attack that?
She can attack it, just not on the grounds she's pressing appeal. The question on preservation is whether or not the district court had a fair opportunity to consider the arguments being made on appeal. The district court.
But here's another line. I mean, the district court specifically says in paragraph 3, quote, the law precludes consideration of what may have been a marital asset that was placed in an irrevocable trust for the benefit of John and Tara's children. I mean, the district court is clearly grappling with this question of whether property within an irrevocable trust is subject to distribution in a marital estate.
Right, but not on the ground that we should adopt a new rule that a court should be allowed to do that if the transfer is made in contemplation of divorce or with the intent.
So your point then is that when the court discusses that in paragraphs 3 through 5, it's not grappling with the argument she's making at all?
No, absolutely not. She never advocated for the adoption of any new rule, let alone the one being argued on appeal. And in fact, she's abandoned on appeal the arguments she actually made to the district court. There were 2 arguments made to the district court. One, that the trust was not validly formed because the stock options could not be transferred without the consent of one spouse. The second argument was that the trust should be reformed under the doctrine of mistake. Those are very, very distinct arguments with very distinct authorities from what is now being pressed on appeal. Moving on, Ms. Hill's second hurdle is the trust code. And our courts will not apply existing precedent in conflict with a valid statute, let alone adopt new precedent in conflict with a valid statute. But
Can I ask you a question about that? You framed this in your brief as if it's an alleged conflict between the trust code and the common law of divorce. But Ms. Hill comes back in response and says, well, no, that it's not a conflict between the trust code and the common law. It's an alleged conflict between the trust code and the divorce code. So it's two statutes in alleged tension rather than a statute in a common law scheme. Why isn't she right about that? Why aren't we looking at the divorce code as
because
opposed to the divorce common law?
Because the divorce code refers to the rights as between the parties, and our appellate courts have consistently held as much. In Andretti and Sundquist, our Supreme Court held that the statute 30-3-5 does not extend to the rights of non-parties. And there's good reason for that, because the district court has equitable jurisdiction over the property of the spousal parties, but when we're talking about non-parties, we have due process issues. And that's why we need a validly pleaded and litigated claim in order to invade the rights of non-spousal parties.
But even there, in its own terms, the argument that you're making would hinge on the meaning of 30-3-5. That's still a statutory argument, isn't it?
But our courts have already interpreted that statute to mean that it doesn't extend to the rights of non-spousal parties. So it would necessarily be a new common law adoption that glosses over that. And I would urge the court to review Dahl. When our Supreme Court was reviewing a similar issue with a revocable trust, our Supreme Court kept its analysis within the confines of the trust code. Our Supreme Court didn't make any suggestion that 30-3-5 could override trust.
Okay, so let me ask you a question then about the trust code. As I understand your argument hinges on 70-7-411, which sets out the three ways in which you can get to an irrevocable trust. The preceding section, 75-7-410, says, quote, in addition to the methods of termination prescribed by section 75-7-411, a trust terminates to the extent that, and then it gives a couple of other options. And one of them is that, quote, the purposes of the trust have become unlawful, contrary to public policy, or impossible to achieve. If I'm reading that correctly, that section, 75-7-410, says that you can also get to an irrevocable trust if its purposes are contrary to public policy. Am I reading that wrong? Am I missing something there?
No, and our brief perhaps stated it a little narrowly. There are a few other ways the trust can be terminated other than 411. There's 411 through 414.
Oh, okay, so if 75-7-410 is applicable, and it does seem to be applicable, and if it says that one of the ways that you can get into an irrevocable trust is if its purposes are contrary to public policy, we have a century of cases saying that we have public policy of dividing marital assets equally. And if the district court here said that these were marital assets, why wouldn't public policy tell us that these should be distributable or dividable within the marital action?
Two reasons. One, that argument was never made before the district court. The district court can't be faulted for not doing something it was never asked to do. Secondly, the public policy argument is an extremely high bar to meet. There has to be a clear statutory statement of public policy. It's not something we just, I can't remember the language, willy-nilly come up with on our own. There has to be a very clear statement of it. And,
why is it not enough to simply recognize that married people should not be able to hide assets from each other using an irrevocable trust? Why isn't that a recognized public policy, or at least adjacent to a recognized public policy?
well, because if the court could point me to a statement by the legislature saying that, then I would agree. But without a statement by the legislature stating that public policy, we don't have a ground to attack it on. See, that's just the analysis our Supreme Court has developed. And that's the remainder of my time is up unless the court has further questions.
And for mine.
Thank you.
Okay, thank you, counsel.
I'll try to be at least a little bit briefer this time around. Just a couple of quick points. First, on preservation, the reason that the district court addressed whether the stock options should be treated as assets of the marital estate is because that was the argument that we advanced in our briefing and in our oral argument. I'm quoting from our brief when we say that John's transfer was invalid, quote, John's transfer was invalid because it was made, quote, with the clear intent to deprive her of her interest in marital property. As a result, the district court could exercise its authority to enter orders regarding the marital property ostensibly held in the trust. That's from page 2060 of the record. Trust counsel himself recognized during oral argument that Dahl versus Dahl and the conflict described in footnote 13 was the Utah case most directly on point to this dispute. And
But wouldn't you at least agree that the thrust of your argument below was that the trust itself was invalid, as opposed to a separate argument that even if it is valid, a court can get into it in the divorce proceeding?
I would agree that the way we framed it was that the trust is invalid. But the reason that the trust is invalid is because it is the recipient of unlawfully transferred assets that were transferred with the intent of defeating the spouse's marital rights.
But then isn't that different? I mean, that's the opposing counsel's point, is that by framing it as an argument about the validity of the trust, that's different than an argument, legally speaking, that's different than an argument about whether a court can get into a valid, irrevocable trust.
And I take that point. My point is that the gist of the argument was that the assets should be treated as marital assets for purposes of equitable distribution because of the way that they were transferred to the trust. And if the line between those two arguments is sufficient to prevent us from making the argument we've made on appeal, then I think that kind of defeats the purpose of preservation. I mean, there's a number of courts or a number of opinions from the Utah Supreme Court talking about the ability to cite additional case law to reframe or to add arguments in support of a properly preserved issue. But if I can turn to the question about the merits, this is a conflict between the conflict described in footnote 13 of Dahl is a conflict between statutes. It's a conflict between 30-3-5 and the trust code. And our point, and if you look at Jackson versus Jackson and a number of other Supreme Court opinions, I mean, it would be difficult to overstate the scope of a district court's equitable authority in divorce proceedings. It's allowed to disregard conveyances. It's allowed to disregard title. It did that in Finlayson, and it did that in some other precedents. And so this equitable authority that 30-3-5 grants and the alleged irrevocability of a trust under the trust code are in conflict as applied here. And so the question we ask is, under what circumstances can we retrieve or invade the assets of that trust in order to fulfill our equitable task to perform justice in this divorce proceeding? And our position is that the circumstances under which you can invade is when the spouse transfers the assets while contemplating divorce or with the intent of depriving the spouse of her marital rights.
Let me just ask a quick question about that conflict, because it seems that even if the court found, as the court did here, that the property in the trust was beyond its reach, because the court did find that it was marital property that was placed into the trust. It just found that it couldn't invade the trust. the court would still have the option, would it not, of finding that the spouse who created the trust was dissipating marital assets and could require that spouse to pay the other spouse 50% of the value of that property. And so I guess I'm just wondering, why is it necessary to advance the public policy of equitable distribution of assets to reach the property in the irrevocable trust itself, if there are other ways that the court can achieve an equitable distribution of property?
I mean, the only thing I would say is that we as lawyers are sometimes guilty of taking a belt and suspenders approach. And I think that, that we are not averse to the possibility. And I completely agree. And if you look at Kim, in fact, it takes exactly that approach, not in the dissipation context, but in the unlawful transfer context. And it says the trust doesn't have to be here. We can just credit those transferred assets against the transferring spouse. And so we're not denying that possibility. We would welcome that possibility. Of course, the court, we think, in an egregiously misguided application of the dissipation elements, went against us on that point. But to the extent we're also seeking to invade the trust had to be a party. And so I would say that we're making these alternative arguments, one that arguably requires us to invade the trust, and the other of which allows the court in equity to credit that amount against the transferring spouse. And with that, I would ask the court to reverse the district court's decision. Thank you.
Great. Thank you, Mr. Mertzen. Mr. Lee, if you could rejoin us for just a moment. I would like to thank counsel for the briefing and the arguments. This was a very well briefed and argued case. Found them both to be very helpful. And with that, I think we'll be adjourned.
Thank you.